Good morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. We will start our day with one Judge J. Cedric Simpson, Washtenaw County, Michigan. Never heard of this guy before. Let's see what he's got going on.
Let me pass that one briefly. The court does call the case of the people versus Aaron Hudge Peterson.
Andrew Bannis with the people.
Morning, Your Honor. Dan Guerin on behalf of Mr. Hudge Peterson.
Aaron Hudge Peterson, Your Honor.
Thank you, sir.
Your Honor, you're going to love this. May I approach for all of 30 seconds with Mr. Bannis?
Pardon?
May we approach for 30 seconds?
Yes.
Thank you.
Briefly.
You want me to?
Here we go.
And just that quickly, Judge has muted, but it gives me an opportunity to thank Barbara for already gifting a membership. Very much appreciate that. Kessa, you are now a member. Congratulations. And once again, good morning, everybody.
We're at discovery and I've also discussed, Your Honor, some bond considerations. I'll discuss that with Mr. Bannis as well.
All right. How long will it take you to get some of that? Will the 16th work for you?
That'd be great, Your Honor. Thank you.
All right. Probable cause conference, October 16th, 2025, 9 a.m. bound.
Thank you very much, Your Honor.
Thank you. Court does call the case of the people versus Timothy Flood.
Ready, Your Honor.
Under Joe Simon on behalf of Mr. Flood, state your name, Timothy Flood.
Thank you.
Your Honor, Ms. Willenbringer and I have been in discussions. She tells me the matter is going to be handed off to a different APA. I've made a proposed resolution. We're asking for an adjourned PCC to continue those discussions.
That's correct.
Probable cause conference, October 9th.
Your Honor, I'm traveling that day. I know I have another one that day, but I'm actually going to have someone cover. Could we have the next available, please?
16th, 2025, 9 a.m.
Thank you, Your Honor. Wait for me out. Actually, just go home. Go home.
The court calls the case people versus Jamie Burke.
Andrew Bannis with the people.
Your Honor, Alexis Plume, appearing with and on behalf of Mr. Burke. Mr. Burke, could you state your full name for the record?
Absolutely. Good morning, Your Honor. My name is Jamie Burke.
Thank you.
Your Honor, at this time, we are requesting a preliminary examination. To my knowledge, discovery is complete.
Where's my day? No, I can't. Oh, no, you're right.
Yeah.
All right. People have their witnesses available October 14th.
I believe so, Your Honor.
Preliminary examination without objection, October 14th, 2025, 9 a.m. before Judge Washington.
Thank you.
Thank you, Your Honor.
Thank you. Bond continue. Court does call the case people versus Amanda Lawrence.
Ready, Your Honor.
My recalls. What recall?
Andrew Bannister's people.
Your Honor, Joe Simon on behalf of Ms. Lawrence. State your name, Amanda.
Amanda Lawrence.
Your Honor, I became engaged yesterday and we substituted in.
I think it's already married.
Ha! You know what the
It
penalty,
was too easy, Joe.
do you know what the penalty for bigamy is, Your Honor?
I do. Did you know?
Two mother-in-law. No, go ahead. No, sorry.
Wow.
No, that's what I heard. And anyway,
Wow. Well, you said that out loud.
I know. It's an
You
oldie.
want an adjournment,
It's an
right?
oldie. Yes, please.
Wow.
Ah.
On behalf of Mr. Simon, I apologize. October 16th, 2025, 9 a.m. Bond
Thank
continued.
you, Your Honor.
Wow. Oh. Feel that way? Never mind. You're not even getting into it. Court calls the case, People versus Devontae Connor Belcher.
And on behalf of the people,
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Connor.
Guys, you're
Bell.
gonna have to make sure you make room for transport to get through. And pay attention when they're coming through. Your name, sir?
Devontae.
Your Honor, we're asking to set this matter for a preliminary examination.
Discovery is complete.
Yes, Judge, to the best of my knowledge.
Preliminary examination in this matter will be in person, October 14th, 2025, 9 a.m. before Judge Valvo.
Like we heard on bond, Judge.
Briefly,
Thank you. Mr. Connor Belcher is here. I have his father is also here in court. His father has indicated that he can reside with him during the pendency of this matter. Mr. Belcher is stays in Ann Arbor. I don't think he's a flight risk in this matter. He could be tethered. I'm not going to gild the lily. His father did indicate he lives at Avalon. But I think the 14-day rule for guests would be pretty well satisfied.
not object to any modification. This case involves the defendant stiff-arming the victim in the chest and stomach multiple times and strangling the victim. He also has holds in this county. He has 2 retail fraud second hold out of 1481 that's up on 1015 with the 1,010% bond. He also has a wrong disorderly out of 15 that's up 1023 with the 1,010%. He also has holds out of Livonia for disorderly for $585 and Van Buren for fraud with 5,010% bond. So at this point, I'd be asking the property to set.
Your Honor, in looking at XGL, I don't see that the out county jurisdictions would are looking to pick them up on these, and the bonds in the other cases total to $300 total.
right. Court, in considering all of that, the court is going to deny the request to modify bond at this time. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Jack Sophia.
Yeah,
Prosecutor.
good morning, Tom Pietrowski on behalf of Mr. Sophia. Jack, identify yourself, please. State your name and get unmuted.
Jack Sophia Jr.
Thank you, sir.
I need a camera, sir, but go ahead. What are we doing?
We'd be, after discussion with Mr. Sophia, we would be waiving the exam, Your Honor. This is a case to be bound over.
Sir? You're going to waive your right to a preliminary examination?
Unmute, Jack. Unmute, Jack.
Yes,
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
yes,
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
yes,
People also waive their right.
We do.
Preliminary examination having been waived, defendant bound over to circuit court on count 1 with 2 following. Mr. Pietrowski.
We waive formal reading, stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
November 25th at 1:30 with Judge Cup.
November 25th, 2025, 1:30 before Judge Kunke.
Does the court have any flexibility with that date, or should I take it up with Judge Kunke?
You're going to take it up with Judge Kunke.
Thank you, Your Honor. Can I
Bond will continue.
Can I
Thank you.
approach to sign the information?
Thank you, Your Honor.
Thank you. Court does call the case People versus Stephen Grisbeck. 3 cases.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Grisbeck.
Assistant Public Defender Chelsea Virgils with and on behalf of Stephen Grisbeck.
Your name?
Stephen Grisbeck.
Thank you.
Your Honor, asking the court to set these cases for.
And likewise on my cases.
So all discovery is complete on these matters.
Yes, Your Honor.
To the best of my knowledge, yes, Your Honor.
People have their witnesses available the 14th. I'll take that as a yes. Preliminary examination in person, October 14th, 2025, 9 a.m. That's before Judge Washington.
Thank you, Your Honor.
Bond will continue.
Thank you, Your Honor.
Let me get this. Court does call the case People versus Alicia Cargill.
Good morning, Rob J. Killen, Cargill. Cargill, would you state your name for the record? Judge, while we're waiting, just a brief history. I did see Ms. Cargill at the prison on August 20th. On September 12th and September 19th, I went to the prison. They could not find a computer to play the disc. They finally found one and called me. I went yesterday to see Ms. Cargill to play the disc. She refused to see me. So I'm not sure where we are in this matter, Judge.
State your name, please.
Alicia Cargill.
Thank you. All right. What would you like me to do with this matter?
Ms. Cargill, if I come out to see you to play the video, are you going to see me?
Yeah. At this point, I don't want an attorney.
You what?
I do not want an attorney. You're stating
At
things
all?
that are not true. You came up here and you were how late? So yeah, I was no longer at Control Center an hour after the time that was scheduled. You're right, but it's not that I refused to see you. I sat up here for an hour yesterday. You did not show up. You were late, extremely
Cargill,
late. So miss me with that. I don't want no attorney. I represent myself.
Ms. Cargill, hold on. So is it right now that you don't want an attorney at all? Or
yeah, at this point, I can represent myself. He still hasn't sent me my discovery. He came out here over a month ago. I asked for a discovery. I'm yet to receive any paperwork about this case at all. I don't know anything that's going on.
okay, so you want to represent yourself?
Yes.
Okay, I'd have to advise you that might not be advisable to represent yourself in this case. You are charged with the offense of assault with intent to do great bodily harm less than murder or by strangulation. That is a felony punishable by up to 10 years incarceration and or a $5,000 fine plus court costs. Do you understand all of that?
No, because when I got arraigned, that's not what I was charged with.
You understand also that if you do represent yourself, you will be held to the same standards as any attorney, that the court will not be assisting you in any way in your representation. You understand that, sir?
I do not want this attorney. So it doesn't, at the end of the day, and then you're sitting here telling me new charges that's not what I was arraigned under. I was arraigned under assault or whatever with less than whatever. Nothing with strangulation.
Sir,
this is news.
Ma'am,
so I'm confused.
That's the charge that I have before me. That's why I'm apprising you of what the charges are. You wish to represent yourself. I've told you that you will be held to the same standards. The court would also indicate that if at some time you wish to be to have the representation of counsel, you need to just request that of the court, and the court will oblige and make sure that you are represented by counsel. Do you understand all of that?
I understand everything you're saying.
Okay. Do you wish, so what do you wish for me to do today? Adjourn the matter so you can get discovery, or what do you want me to do?
I mean, I want my discovery I'm entitled to. I want to be represented properly if I'm gonna be represented. I don't want to hear, like, I don't understand. So,
You want me to adjourn the matter out so that you can get all that information and make your decision, or what do you want me to do?
I can't go in the breakout room with my attorney or anything. I'm confused. I don't get this.
I am not gonna do that, sir, ma'am.
Okay, well, I'm not I didn't consent to Zoom either, so I don't know what's going on.
Judge, I'm just for the record, never mind. I'm not trying to get into argument. We went over the discovery. I was 10 minutes late yesterday. They could not find a computer to play my disc. That was the delay, Mr. Cargill. Now, I sat there for close to 45 minutes before they told me they had a computer to play your disc.
Well, I think you need to get the discovery to the person. I am going to find good cause to adjourn this proceeding since nobody will give me an answer of what they want to do. I will adjourn it 2 weeks out. I need 2 weeks for the writ in any event. So it's going to have to be October 16th, that following Thursday from the Tuesday. October 16th, 2025, 9 a.m. Bond continued. Thank you.
I'm sorry, I'm on vacation.
Well, he wants to represent himself. I don't know what you guys are going to do. I'm setting it for that date. You can talk to each other, make your decision. If it looks like you are going to be representing this individual, Mr. Killowald, then certainly you can seek an adjournment from the prosecutor to set a date. Thank you. I'll continue.
Well, that'll be a fun one to keep an eye on. Good morning once again, everybody. Welcome to the Courtroom Files Live. We'll come back to Judge Simpson in a little bit, but let's head down to Florida to see what's going on this morning with Judge Mercer.
Mr. Quintana, good morning. Mr. Quintana, you're here for first appearance. You're accused of 2 charges. They are reckless driving and refusal to submit to a breathalyzer blood alcohol test. Mr. Quintana, I read the complaint. Mr. McDaniel has expressed some concerns about probable cause. So before I go any further, let me hear from the attorneys on those issues. Mr. McDaniel.
Your Honor, on the charge of not taking the blood tests, Your Honor, there's nothing in the complaint listed to be prior refusals to take a blood test or an alcohol test. I couldn't find one, and there's nothing in there listed about any priors, which is the current law that it has to be a prior. So I don't think there's any probable cause for that. On the actual charge of reckless driving, Your Honor, not saying that there's not probable cause of a crime, possibly, but there's not probable cause for arrest because none of the actions took place in the presence of an officer. They're relying on hearsay evidence from the security guard, which is not something they can make an arrest on. Not saying that there's not probable cause for possibly a crime, but there's nothing there as far as probable cause for arrest.
All right, so thank you, Mr. Mitchell. Let me take them separately. So the first issue he raised is that the refusal to submit a breathalyzer as of today is a crime only if you have a prior refusal, correct?
Correct.
And that law changes tomorrow.
Correct.
But as of today, and as of yesterday when he was arrested, your first refusal, at least until tomorrow, is not a criminal charge. It may or may not be a civil infraction. I have no idea, but it's definitely not criminal. Do you agree with that?
I agree with that, Your Honor.
So since there's no probable cause for that charge, we move on to the reckless driving. And as a general rule, reckless driving is not an offense an officer can make an arrest for if it occurs outside of his or her presence. Is that correct?
Yes, Your Honor. When Mr. McDaniel sent an email to us both, and I had time to look over a case that is very relevant on this matter, which was Atwell v. State, and we're in agreement based on the ruling of that case.
So here's my question, and I have no problem with that. But my question is, had this happened tomorrow or after midnight tonight, there would have been probable cause, arguably, depending on the complaint, for the refusal, because the refusal would have occurred in the officer's presence.
That is correct.
But he still couldn't have arrested for the reckless driving. He could only have arrested for the refusal.
Based on the case law that I've looked at, that is correct, Your Honor.
All right, so Mr. Quintana, what I'm going to do is I'm going to find no probable cause on the refusal, because that, as of today, that appears not to be a criminal charge for your first refusal. There's no evidence in the complaint that you had a prior refusal. That changes tomorrow. Starting October 1st, 2025, your first refusal in Florida is a second-degree misdemeanor. But as of September 30th, 2025, your first refusal is not a crime. That changes at midnight tonight. So there's no probable cause on that. And as for the second charge, both the state and defense agree that reckless driving occurring outside the officer's presence is not an arrestable offense. So it's really not a probable cause determination. It's a determination that you couldn't be arrested for that. You could have been charged. The officer could have done a citation and charged you with that, but he couldn't arrested you. So it's one of those cases, which is rare, where the officers are apparently are trained and knowledgeable about the law, just possibly one day early in the law. I guess I'd rather have that than
Not at all.
I have cases where the law's been changed for 3 years and some officers still don't know it. So this officer just might have jumped the gun a little bit, it appears. So Mr. Quintana, I can't hold you. I can't hold you if the arrest appears to be inappropriate for any reason, or if the arrest is inappropriate for any reason, whether it's probable cause or an inappropriate warrantless arrest. So in this case, I have no choice. I'm going to release you for no probable cause on one count and a crime allegedly occurring outside the officer's presence that's not an arrestable offense on the other count. You're going to be released. I'm going to give you a notice for your court date, or I'm going to ask the jail to give you a notice for your court date, and that'll give the state and defense time to research this issue. You got one case that looks like the state may not be able to go forward with, one case they possibly can go forward with. That's the reckless driving. And what would this court date be? October 27th at 9 o'clock will be his court date, Corporal. And Mr. Quintana, they'll give you a notice for that court date before you leave the jail. Mr. Quintana, do you have any questions?
No, sir.
Have a good day, sir.
Thank you.
No, it's the reckless driving. There is PC. It's just not an arrestable offense. There's no PC on the refusal. We have Regina Whitehead next. Ms. Whitehead, good morning. Ms. Whitehead, I had to call the jail this morning to get some clarification. It looks like you first appeared by Judge Peel last week. You were held 7 days. This first appearance sheet from that date doesn't say what for. Sergeant Gross advised me this morning the reason you were held 7 days was because of possible holds out of Calhoun and Liberty. He also, counties that is, he also advised me this morning that they now have warrants. Both of those counties have no bond violation of probation warrants for you. So be aware of that, Ms. Whitehead. If you post bond, you'll be held for those counties. If you don't post bond, you're probably going to deal with our case first. And then after our case is over, you'll deal with those counties if they still want you. Ms. Whitehead, do you have any questions?
Is there any way to get a bond reduction?
On the Jackson County case?
Yes, sir. I don't have any family to help me.
Yeah, if you're on probation in two, you got to understand, if you're on probation in two counties and they both have no bond warrants, if a bond reduction was granted, then you wouldn't get out. If you posted, you would simply go to one of those jails. Secondly, if you're on probation already in two counties and you're accused of trafficking, then I would think the bond set looks to be reasonable based upon our standard bonds. I've not read the complaints. I'm not going to tell you can't get a bond reduction. You want to file a motion or an attorney file a motion for you. I can tell you that you being on probation certainly doesn't help things as far as your bond goes. I always said a higher bond. A lot of judges set a higher bond for somebody on probation than someone who's not. So I can't tell you you're not entitled to one, or at least try. But you're certainly not going to get one today. The state's entitled to 3 days notice on any bond reduction motion, okay?
Yes, sir.
Have a good day, ma'am. We have Friendly Francois next. I believe hopefully I'm pronouncing that right. Good morning, sir. Sir, you're here for first appearance accused of one count of violation in terms of your pretrial intervention and conditional release. You will have to adjust the camera so we can see him out there, Corporal. We can't see Mr. Francois.
No, it's all right. You don't need
to. No, it's okay.
Joking.
There we go. That's better. So you're accused of violating in terms of your pretrial intervention in case 25172 MM. I'm going to appoint the public defender's officer to represent you, sir, and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Francois. He's going to enter a plea of no contest to the charge. Understanding he's going to be sentenced to 2 days jail, 6 months probation, no early termination, and whatever the restitution and fine is owed, continue to make the restitution and fine payments. My only question is did you want him to get out today or tomorrow, I guess?
No, the last gentleman that we had this for, I made him stay over the weekend. It was another Chipola basketball player. I think we have out of 6 that got arrested in these string of shopliftings, 4 of them have either are warrant status or have been warrant status. It wasn't a very successful plan that we had. And that gentleman stayed in jail from Friday to Monday. So I would want to treat this person as, I think it's Friday to Monday. I want to treat him the same. So if he was arrested yesterday, he would get out after 48 hours essentially, which would be tomorrow morning.
So 3 days jail, 1 day.
Let me ask a question. I don't know when he was arrested or where. When and where was he arrested, Mr. McDaniel? He may have been arrested in another county for all I know.
I talked to him in the program, I don't know, a few weeks ago, and I told him to turn himself in when the program talked to him. Yeah, he turned himself in because this program called me about it, and I talked to the, FSU about it or whatever.
When did he turn himself in and where? Because if he turned himself in another county, he may already have this credit. I have no idea.
Yesterday at Jackson County.
Yesterday here in Jackson County.
Okay. So then 48 hours would be
Yesterday in Jackson County, so
yeah. So
I think he's gotten it.
No, he would. So let me think. So the last gentleman, I saw him at first appearance on a Friday. So he had turned himself in on Thursday, or he got arrested on Thursday. He got out Monday. So he stayed from first appearance. He stayed. Is that right? So I'm fine with just say 2 days. He's got 1 day credit. He's going to be released tomorrow. Mr. Mitchell, you okay with that?
I'm fine with that.
Just to keep it correct, that'd be 3 days jail, 1 day credit, because today, when they put it in the system, it's going to calculate as a day, and then tomorrow would be a day.
That computer system does constantly give me trouble. Yeah, I think you're right. So the plan would be for you to be released tomorrow. So you're going to get credit for today when they put it in the computer. And just to be clear, I'm going to direct the judge to release him tomorrow morning. That way it's absolutely clear. He's going to be released on October 1st. You're going to get out of jail tomorrow on probation. Mr. Friendly,
Yes,
if you do as good on probation as you had done on pretrial intervention, then it's just a matter of time. You did basically nothing. You just did nothing. If you do that on probation, there's going to be a warrant for your arrest, and it's not going to be a couple of days in jail, and you're not going to get another shot at probation. If that happens and you violate probation, what normally will happen is you're going to get about 30 days in jail if it's proven. So you got to take this a whole lot more seriously than it appears you may have taken it thus far. Any questions about any of that?
The judge just let the court be aware. He's procrastinating. I'm not disagreeing with any of that, but I think they told me that he had done the class and he just hasn't turned it in. Is that still accurate?
Yes.
Yes, I think some of it's procrastinating. They're just not, it is.
According to his affidavit, he did nothing at all. So, Mr. Friendly, let me go back to my question. You understand you got to take this seriously, sir?
Yes, sir. Yes,
and
sir.
Is this the plea you would like to enter, sir?
Yes, sir.
Mr. Goodson?
So he had a $370 fine balance, Judge. He had a $198.04 restitution, which Mr. Mitchell, I assume that was the restitution for several cases. You only prosecuted one, correct?
Correct.
So are you still gonna, upon him completing this probation, you're gonna dismiss the others just as it was on the PTI?
I don't think on the other case, you didn't dismiss it upon him completing it. You dismissed it upon him pleading.
Okay. All right.
Because you said since he's on probation and not PTI, I'm going to go ahead and dismiss the other cases. I just want you to remind you, because I know you try to be consistent too.
That is correct. That's what I did. When it's PTI, I will wait until they complete it to not file in the other cases. But when it's probation, I'll dismiss them once he pleads probation. So I will do the same here.
So for his benefit, do we have the case numbers of the ones that you are going to be dismissing today? The state's going to dismiss the other cases now that you're on probation. So, and if you don't have the case numbers, it'll be the same case numbers that they were holding, or originally they were just holding those cases. Now they're going to go ahead and dismiss them. And knowing all of that, is this the plea you would like to enter, sir?
Yes, sir.
Mr.
So there was a condition of the PTI that he would have no contact with any Walmart. I assume that's still going to be in place.
Absolutely. That's the standard. Yes, sir. That's the standard condition.
For the probation department's clarification, if it's okay with the judge, if they bring him up this morning, Mr. Ham can go ahead and instruct him, and he can be released tomorrow morning if that's the.
Yeah, thank you for bringing that up. So Corporal, we want to go ahead and get Mr. It's Francois. We want to get Mr. Francois instructed today. Am I pronouncing that correct, sir?
Yes, sir.
We want to get him instructed today. And the reason we're going to do that, Mr. Francois, is when you're released tomorrow, I want you to be released. I don't want you to have to come to the probation office and be instructed. I want to go ahead and get that out of the way. So the jail's going to bring you to the probation office this morning, get you instructed on the terms of probation. You'll go back to the jail. You'll spend the night. Tomorrow morning, you get out. And when you get out tomorrow morning, you already know the rules of probation. You know when you got to check in again. You're free to go as long as you check in again when you're supposed to. I'll see if you have any questions in just a second. I don't think I've actually accepted the plea. I'm going to accept the plea of no contest.
Judge, can I ask you a question privately?
Sure.
Real quick, like, or just.
Are you through with that disposition? Yes, it's a withhold.
I was about to look it up, but my VPN disconnected, so.
Am I right, though? You view those differently on the probation. You went ahead and dismissed them then, which is logical.
Yeah.
No,
That makes sense.
Your Honor, no other questions. I had to ask him, I guess, a question about immigration status, but that's not an issue.
Mr. Francois, I'm going to accept the plea of no contest in case 25-172 MM to one charge of petty theft. Withhold adjudication of guilt, sentence you to 3 days in jail, give you credit for 1 day. You're going to get credit for today in the computer, and you'll get credit for tomorrow morning. So tomorrow you'll be released tomorrow morning, October 1st. Just make that clear. You're going to be on 6 months probation. You're going to have a condition that you pay court costs and fines of $370, which is the same amount you were ordered to pay originally on the PTI, and restitution of $198.04. The clerk's office has a fee they can charge per restitution payment per statute. No contact with any Walmart, no early termination of probation. So Mr. Francois, we'll get you out of there tomorrow morning. You're going to get instructed today, and just please take this seriously. Get this all behind you, and I do wish you the best. Mr. Francois, do you have any questions?
Well, I do. I do want to say thank you to you, Judge. And I was just asking, so when I was in school, well, right now I'm in school in Arkansas. I used to go to Chipotle. I had to transfer over to Arkansas, and I was talking to a man. His name Marvin Moody. He taught he know the POs and stuff out there, and it was a question I was just told to ask him. Is it possible I get a PO up there so things get a little easier, or?
We don't transfer probation, and a lot of county courts don't do that. What we do instead is we let you report by mail or email. So what I would do is, my son's a student athlete, and they have athletic departments have people to help you keep track of your schedule. You got somebody like that in your program up there at Arkansas?
No, but I have to find one. I could definitely find one.
You need to talk to one of your assistant coaches and say, I need you to help me remember I've got to report in every month by mail or email, and that assistant coach stay on top of you, make sure you get your stuff sent in every month, because I don't want you to get up there and get involved in the season, which is about to start, and get distracted and forget. If you don't report in next time, then the consequences become jail sentence. I'm not going to put you on probation again. The only reason I'm doing it this time is because it appears you honestly I think you may have done what you're supposed to do until your summer started. And when you got away from the help of the Chipotle coaches, and you got up there, got wherever you were at, you kind of got lost in the jumble. So we don't transfer cases. My probation officers do anything they can to help you succeed. They want you to be a success. We want you to get this behind you, but you do have to send in reports once a month, either by mail or email. And if you don't, that's the same as not reporting. So I'm going to suggest you talk to one of your assistant coaches, or what's the other one? They have grad assistants. A lot of Division I programs have grad assistants that will help you with academics or other obligations. And that's who I would be talking to, put on some kind of counter so they remind you. I think that's your best bet. Are you at Arkansas or another University of Arkansas or a different school?
No, I'm at it's called National Park College.
Okay.
I was going to go to FAMU, but I just went to National Park College to finish out my 2 JUCO years.
But one of your other Chipotle basketball players that is a FAMU student athlete has a warrant for him from the same situation. You probably know what I'm talking about. So hopefully we're going to be seeing him in the near future, and we're going to try to treat him the same as we treated you and the other young man that did well until the summer started. So we have, I think, There were 6 cases. 2 of them did what they were supposed to do. 4 of them are in violation status or were. And now you and one other young man have resolved the case and hopefully just put it all behind you. I wish you the best, sir.
Thank you, sir.
Thank you. I believe that's everything for first appearance purposes. Mr. Mitchell, anything else from the state?
Okie dokie, since he's winding things up, let's go to... Where do we want to go? Texas, Judge Stevens.
Appeal 5-5 is now called the State of Texas versus Kiana Walker. That is you.
Yes, sir.
Present with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary? Yes, sir, we can. In summary, ma'am, this indictment that was handed up by the grand jury, it looks, well, going on almost 2 years now. It states that on or about October 12th, 2023 in Jefferson County, Texas, you committed the state jail felony of theft. It looks like perfume or fragrances like that at the Ulta Beauty Supply in Plugdale Mall. Do you understand what you're charged with here?
Yes, sir.
A state jail felony, if convicted, this means that you face confinement in the state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be sentenced to 180 days in the state jail. Is that your understanding of the agreement? Is that right? Yes. Because she's got credit for more than that. Is there any restitution here? It's been paid.
It's ordered to be paid by a different defendant, Judge.
I just want to make sure that people who were victims get their value back.
Yes, sir.
We're talking about $2,500 worth of merchandise. What is this? Oh, it was a all-out blitz by a group. How is this money being paid back?
The code.
It's going to get paid back, or I won't take the deal.
It's already been ordered by the co-defendant.
That's correct.
I don't know if it's been fully done or not. But the offer was, we did no restitution would be ordered on this lady because it already been ordered.
So from the state, where is it?
It's been, as I said, Judge, it's ordered to be paid by
I know it's ordered.
the defendant. I do not know the status of its collection.
See, the problem with that is that's a defendant. Or a lot of defendants are ordered to do things in this courtroom and they don't. And then doesn't get done. And then people who are responsible, who are parties to the event, who say, well, that guy was supposed to do it. Well, everybody's equally responsible. Everybody is equally responsible. Just because somebody takes responsibility to pay, if they don't pay, then the business owners go, hey, what about us? What happened to us? We're supposed to get paid back.
We were presented this agreement by the defense judge. I had not had an opportunity to determine where the restitution collection is at.
Well, I'm not going to go on the word of somebody who's charged with being a thief. I mean, we're going to have to get this satisfied because that's what victims plead for, to fix it. So you pay them back. If you don't pay them back, they get victimized twice. Until I'm sure that is done, I'm not taking anything. Okay, I'm ready to set it a couple of weeks. All right. So we'll do. Get a reset.
Kind of resetting and be back here. I'll just have.
You said she's already served.
Yeah, she's already got credit for that.
Okay.
She did that much time.
Well, but still, people, the victims are gonna get taken care of. That's just the way it is. That's the way
The
it
state had
happens.
just advised me what necessary here because it already been ordered, so.
I know it's harder, but it hadn't been, they gotta come through with
Understand?
the promise. There's defendants, a lot of times makes promises that where they don't fulfill their.
All right, let's head back up to Michigan and we'll go back to Judge Simpson.
Yes. They are not present.
Would you mind passing this so I can call the client, Your Honor?
Yes, I would,
Thank you.
because I don't know why they're not here.
Me either.
Bench warrant will issue for defendant's failure to appear. Bond in each case will be set in the amount of $10,000 cash surety. Warrants will issue immediately. Thank you. Court calls case People versus Cedric Green.
Ready, Judge, Torshell Future Assistant Public Defender on behalf of Mr. Green. On one file.
Morning. Good morning, Your Honor. Christina Costantino on behalf of Mr. Green in the other file.
She just appeared out of nowhere. She's so short, we didn't even see her. All right.
Magic.
Good morning. Your name, sir? Cedric Green. Thank you.
Thank you, Judge. I have spoken to Mr. Green. We have discussed his file that I have. I believe he still wants a preliminary on that file. I'm not sure what he wants to do on Mrs. Constantino's file.
Same, Judge. We would be asking for a preliminary exam date. Discovery is complete as to my knowledge.
Likewise.
I know.
And they didn't see.
I will let the judge know that.
People have their witnesses available the 14th.
I believe so, Your Honor.
Preliminary examination in person, October 14th, 2025, 9 a.m. These are set, will be set before Judge Valvo. Bond will continue. Thank you.
And
I'm sure Mr.
Judge,
Green wants to address the bond.
Yes.
yes, Judge, he does wish for us to address his bond. He currently has a bond set that he cannot post, and the reason for that is due to a missed court date. I was told by my client as well as another attorney who was present the day of that court date that Mr. Green did appear in court that day. He was just late. He was on the 9 a.m. time block, and he did appear at, I think, around noon. Is that correct, Mr. Green?
My bus guy here like a. Are you
He's
aware of
indicated-
the Ann Arbor Police Department report bond violation?
No, Judge.
Oh, okay. Go ahead.
I
Judge-
just join my colleague's bond motion, Judge.
Pardon?
Yes,
I have nothing additional to add. I'll join Ms. Constantino's bond motion.
Judge, we just want you to know he did appear in court that day. His bus was running late. That was the reason he was late to court. He did appear physically that day. But for the warrant being issued that day, he would have been out on his own recognizance. Sorry, what?
I have a bond violation, a conditional bond violation, at least police report. His missed appearance was on September 11th. He had police contact on September 20th, which is, I do believe, what then brought him into custody. From the 11th, he did not do anything to appear before the court. So for those reasons, his the request for bond modification or reduction is denied. Bond will continue as is.
Thank you, Judge.
Thank you. Court calls case People versus Randall Jolly. I'm not even gonna begin this plea. Do I have an advice of rights form?
You should. We filled it out, put it in the file.
They're gonna need to do it that day. I'm not gonna sit around. Okay. Go ahead. What are we doing?
Your Honor, we are offering a plea if the court will accept it.
I have before me the plea form that indicates that the defendant will be pleading guilty to the charge of use of amphetamines, that being Adderall, first offense, the 1 year charge. That upon his successful plea to that charge, counts 1 and 2 would be dismissed. There is a sentence agreement. Well, it indicates here defendant is not eligible for 7411 treatment. That's the court's full understanding of the agreement.
It is ours as well, Your Honor.
That's correct. May I have him sworn?
Raise the right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Randall Jolly.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of an amphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes, sir.
And you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court.
Understand.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
You signed an advice of rights form, is that correct?
I did, yeah.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes, sir.
Of your own free will?
Yes.
And because you believe that you're guilty?
Yes.
July 2nd, 2024, I-94 near M52 in Sylvan Township, Washtenaw County, State of Michigan. Did you have Adderall in your possession?
Yes, Your Honor.
Did you have a current prescription for that?
No, sir.
Did you know what you had in your possession was Adderall?
Yes.
And had you used it?
Yes.
Sir, I do have to advise you that if the court does accept your plea, that if you commit misconduct between the time that I do accept your plea and the time of sentencing, any sentence agreement evaluation by the court would no longer be bound by, and you would not be permitted to withdraw your plea. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which had led to this plea?
No, Your Honor.
There are none.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, the people are satisfied.
Satisfied, Judge.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
November 3rd at 9 a.m.
November 3rd, 2025, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Thank you. Bond continued.
Thank you, sir.
Does my client report to probation in this today?
He can go right down to probation and they'll take care of it.
Thank you.
Court calls case People versus Dustin Duncan.
Assistant Public Defender Ben Dunawith on behalf of Mr. Duncan, who is approaching the podium now. Mr. Duncan, would you state your name for the record, please?
Dustin Duncan.
Thank you.
And Your Honor, defense would like an exam date.
Discovery complete.
Yes, Your Honor.
People have their witnesses available the 14th.
I believe so, Your Honor.
Preliminary examination will be set in person October 14th, 2025, 9 a.m. before Judge Washington.
Thank you.
Bond continued. Thank you.
Mailed you.
Court calls case of the People versus Cameron Baker.
Good morning, Your Honor. Daniel Schuman appearing on behalf of Mr. Baker.
State your name, sir.
My name is Cameron Baker, Your Honor.
Thank you. All right, what are we doing?
Your Honor, we've been recently retained on the matter, did receive discovery. I believe it's complete, but we just received it. I'm looking for an opportunity to further discuss this matter with my client and the prosecution. May we adjourn the exam to October 16th? The PCC, I'm sorry.
Without objection, October 16th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case People versus Robin Finney.
Andrew Vanish with people.
Good morning, Your Honor. Assistant Public Defender Constable Basin on behalf of Robin Finney, who's approaching to my right. Can you state your full name for the record, please?
Yes, Robin Lee Finney.
Thank you.
Your Honor, at this time, we're going to be requesting an adjournment. My client is waiting to get into Bear River. She's on the wait list.
For release to inpatient.
Yes. So we would ask for about at least a month adjournment at this point.
She held on anything else or just this case?
Just this case.
I mean, I'll grant that, but October 30th. October 30th. She is, thank you, that's fine. I'll take that representation. Probable cause, October 30th, 2025, 9 a.m. Bond continued. Thank you, Mr.
All right, we'll keep an eye on the goings on there, but let's go to Texas. 9 to 11% more Judge Boyd in action.
And are you Andrew Thomas Reyes? Counsel, in each cause number, have you received all the discovery and that you review that discovery with your client?
I have, Your Honor, and we have signed a document indicating that we have received all this stuff.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Reyes, in cause number 2025 CR 011977, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure?
Yes.
Did you understand in that cause number, you have a right to have a grand jury review the evidence and make a decision on whether or not there's enough evidence to hold you over for trial, and also that your attorney has certain rights. Your attorney has the right to have the passage of 2 days once they are presented with the information and 10 days to prepare for trial. Did you understand?
Yes.
Did you understand by entering this plea, you're giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. And each cause number, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes.
All right, off the record, to the clerk. Adriana? Yes, ma'am. I don't have the information in this cause number. Yes, please.
It's just the unofficial signed one.
All right,
Unsigned.
and if you can make sure also, Adriana, that you have that.
You did the original one with the paperwork.
All right, we'll need to make sure that we have that before things are done. All right. Did you review the felony information with your attorney? Did you understand it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, in each of those, are you waiving the reading?
We are, Your Honor.
State in the cause number that is the felony information, are you proceeding on that information as presented?
We are, Your Honor.
And the other cause number, are you proceeding on the indictment as presented?
No, Your Honor, we will waive count 1 of the indictment and proceed on count 2. No objections, Your Honor.
All right, in each of the cause numbers, did you review the documents entitled Court Admonishments with your attorney? Did you understand them and did you sign them in all the appropriate places?
Yes.
And cause number 2025 CR 07562A. You're charged with possession of a controlled substance, penalty group 2, 4 to 200 grams. 4 to 400 grams as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to a $10,000 fine. Did you understand?
Yes.
And the felony information, you are charged with endangering a child through criminal negligence as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have plea bargain agreements with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into these plea bargain agreements, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cases?
Yes.
Counsel, in each cause number, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Reyes, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
I am.
Did you understand by entering into plea bargain agreements in each of these cause numbers, if you're not a U.S. citizen, you will be deported, not allowed re-entry and denied naturalization. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea in the felony information case, punishment is to be assessed at a $1,500 fine. State recommends deferred adjudication. This will run concurrent with 2025 CR 007562A. And the other cause number, the state is proceeding on count 2. There's a $2,000 fine. The state recommends deferred adjudication, and it will run concurrently with the previous case. Did you understand that to be the plea?
Yes.
Defense?
It is.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, in the felony information case, the state is asking that your community supervision be for a term of 2 years. There'll be 100 hours of community service restitution, no contact with Skylar Reyes, parenting classes, TAP evaluation, follow all recommendations in the MRT. In the indicted case, the state is asking that your deferred adjudication be for a term of 3 years. There'll be a TAP evaluation, 200 hours of community service restitution, the parenting classes, and more recognition therapy. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
You said no, Your Honor. So you understood that? Okay.
Did you understand that?
Yes.
Then in cause number 2025 CR 007562A to count 2, how do you plead? Guilty, not guilty, or no contest? In 2025 CR 011977, how do you plead?
No contest.
State any evidence.
For both cases, Your Honor, state officers have evidence as exhibit 1 of all attachments.
We've had a chance to review both cases, Your Honor, and find no objections.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and cite it in both places?
Yes.
Did you understand for your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. and the court will review the same. Rick,
Yes, Your Honor.
if you'll just sign this and they'll file stamp it.
Sure.
Thank you.
You're welcome.
Thank you.
You're welcome.
All right, in each cause number, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client is taking full responsibility for what occurred in that house and on that evening. Because of that, Your Honor, and because of the fact that he has a clear record, we would ask that that to be taken into consideration. The first thing we'd like to address is that the no contact order, although the state asked for it, we did go through a proceeding with the child custody people, and they found that he has had no problems with his child. So we would ask that he had at worst, no harmful or injurious contact with his child so that he can see his child. He is supporting the child and taking care of all of his bills. Your Honor, he is working at this time. And so we would ask that the judge take that in consideration when considering, since the two cases are running together, the amount of community service hours that he's doing. The TAP evaluations and the other things I explained to him were things that are probably good that he has to do. He does not have, they've done follicle tests and all kinds of other things, so he did not have any problems with drug use. And so we believe that'll clear him too, and they'll see all that. But we would just ask consideration on the fine, the no contact order, the no harmful or injurious contact, and consideration on the community hours.
All right, state, you want to be heard on the no contact order?
Yes, Your Honor. I wasn't sure if Your Honor would accept me putting in the harmful injurious contact as an option, but I will say we had the co-defendants about a month ago, if you recall, Jacob McNally. And I reviewed the CPS record associated with all three of them, including this defendant, and this defendant seemed to be the most, and he has a CPS, less culpable for the situation. He passed hair follicle very soon, so what they call family plan was cleared sooner than Jacob and Kelly were the other two co-defendants. So state have not had any objection. This particular defendant had no harmful and injurious contact with this.
All right, so were you living with these other people? So how many rooms did this home have?
3 rooms.
All right, and how many bedrooms?
2 at the time that I know of.
So
that
it was
were being used as bedrooms.
2 were being used as bedrooms?
Yeah, the other room I did not.
All right, so where were the adults sleeping? Did the adults have a designated bedroom?
They did, but I know a bed frame like broke in the room, as they told me, so they're like we're sleeping in like the living room area.
So I'm just wondering, why would you all be growing marijuana in a child's bedroom?
I'm sorry?
Why would there be marijuana grown in a child's bedroom as opposed to an adult bedroom?
From what I was being told, one adult bedroom, it was being grown, and in the other room, I'm not sure what was being done in that room.
No, I mean, it was being grown next to a crib unless the adults are sleeping in cribs.
I understand.
So did you and nobody say, hey, you know what? we're gonna go ahead and grow this marijuana, but it's a bridge too far for me to grow marijuana in the baby's bedroom. Did anybody say that?
No one's talking to me about the marijuana itself being grown.
Just to be clear, Your Honor, the baby was the child of the other two people.
Yeah.
His was 9 years old, sleeping in his room with him, so she was not sleeping with the previous side.
Okay, all right, I understand that, but still, somebody is growing, wouldn't you think? I'm trying to figure out what your mindset is.
Right.
Wouldn't the fog clear and you say, you know what, there's just something wrong about people growing marijuana in a bedroom where a baby sleeps? At any point, did somebody say, we have young children here, they shouldn't be around marijuana? And I knew it probably stank. Because we tried a case in this court, and every time they would bring the marijuana out to show to the jury, I ended up getting headaches. It stinks to high heaven. So nobody thought to say, you know what? Let's set up a tent outside if we're going to do this. So at least the children won't be smelling this on a daily. That never occurred to you?
I didn't smell anything, Your Honor, from what Big people telling me. He had, he's like having it.
But I mean, you knew marijuana was being grown. Are you telling me you had no idea marijuana?
I know they were, because they were working at a smoke shop. I didn't know they're actually like farming, as they would say, the marijuana.
So you're saying you had no idea marijuana was being grown?
It was not grown in my room or like in any open area.
No, that's not my
I
question.
did not know, Your Honor.
So then why are you pleading to endangering a child by having dangerous drugs in a household? Then if you had no idea that there was no marijuana, it sounds like maybe you should go to trial on that case.
I just didn't want to risk going to trial and then doing up to 10 years in prison. I can't do that to my daughter, Your Honor.
Well, no, this is the state jail felony.
2 years, oh, okay.
That's the state jail felony. And then on the other one, they charge you with possession. So are you saying you didn't possess any drugs? There was no care, custody, and control?
On my room or my area, no, Your Honor.
All right, does he want a jury trial? He's saying,
Your Honor, I think without him understanding it, the fact that he lived in the house, the fact that there was stuff in the house, I'm not saying, and I can't say on his behalf that he knew personally. I suspect that he had an idea of what was going on because of the business that his ex-wife and her new husband worked at. But I think because he was always gone, he was making plans to get out of the house. He just wanted to leave. And the problem is the incident occurred that brought everybody into the house. So when he and I talked with him, I asked him the same questions. He basically indicated that I think it was a selective ignorance. He didn't want to know, although, like you say, the smell, the signs that were on the walls and things of that nature, if you looked at the videos, would indicate, and where they worked would indicate there was something going on.
so the other co-defendants, what, is that your ex-wife?
My ex-wife, correct.
So you were living in a house with your ex-wife and her new husband?
Yes.
Oh, no, I'm just wondering.
I know it's a strange situation, but we
I've
actually.
seen that on TV, but okay.
But at start, of course, it was a little rough, but we actually get along, so it was working out okay. And I was actually living in my own apartment before, but with a discussion with my ex-wife and myself that our daughter was having a hard time me being out of the home. So after my lease was up, I actually went back into the house so we could be together until she was a little bit more understanding of what was going on for me to leave again. Yeah,
All right, so do you live in the household now?
it's a different house with them
No, but you're not living with the ex-wife and her new husband.
together. So yeah,
So you all are still living together?
it's just been hard financially wise, Your Honor. They actually did help me out by paying my bond. Well, I paid the bond myself and they did reimburse me because they realized the situation they put me in. And I'm just trying to get everything financially wise done so I can actually move out.
So who is your family support other than your ex-wife and her new husband?
All my family got a state here.
All right, and what state?
In Florida.
So do you want to transfer back to Florida or no?
Transfer back to Florida?
I mean-
Or is,
Move back to Florida and have your probation transferred to Florida?
I'd like to keep it here, Your Honor.
And are you employed?
Yes,
What do you do?
I'm with the San Antonio River Authority. I work, I'm as a landscape technician.
All right,
You might see me out driving around later.
all right. So they said that you had a family-based service plan?
Yes, family plan, correct.
All right, so what did you complete
As
with
far
the
as,
family-based service? What did they have you do?
I voluntarily submitted a hair follicle test. That way I could have contact with my daughter immediately upon getting the results. And then I also did see a few more UAs after that with the
Did you
family plan.
complete any parenting classes?
Parenting classes themselves, no. But we did do as far as like visitations from CPS.
I don't know why CPS didn't have them do. Here's the thing, I'm gonna order parenting classes because you need to realize how your actions impact your child. And I don't think people realize that, because a child can't say, I don't want to live in this situation. I don't want marijuana in my bedroom. Because they're a child, they're not an adult. You understand?
I understand.
All right, in cause number 2025 CR 011977, there's going to be a $1,500 fine. That will be probated. 3 years deferred adjudication, concurrent with 2025 CR 007562A. Regular reporting by Zoom or in person, regular random UAs or patch. The patch is more expensive, but it has less time constraints because they will put it on you. You're not allowed to remove it. You'll just report and then they'll remove it and they'll see what the testing says. Field visits 1 time per month until further notice. Proof of employment within 45 days. No employment as a home health care provider or with minors. 100 hours of community service restitution. I'm going to order parenting classes. Once the parenting classes are complete, the community service hours will be deemed satisfied. There's to be no harmful or injurious contact with Skylar Reyes. And there is to be a TAP evaluation. Follow recommendations. Is there anything else that you need from the court in that cause number?
No.
Probation, is there anything else under that cause number? In that case, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
I did, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. In 2025 CR 007562A, the court is going to sentence you to a $2,000 fine. That will be probated. This will run concurrent with 2025 CR 011977. There's to be proof of employment within 45 days. No employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs or the patch. Field visits 1 time per month until further notice. 3 years deferred adjudication. 200 hours of community service restitution. I'm going to order the MRT. Once the MRT is completed, the community service hours will be deemed satisfied. Probation, is there anything else that's needed? All right, and I didn't order the top evaluation in that cause number since you already have it. Is there anything else you need from the court to be successful?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal in
Yes.
that cause number?
Yes.
Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. This is what you have to remember in your life as you go forward. Until your child is an adult, they're dependent on you to make good decisions for them. They can't just say, oh, I'm gonna do something else, because they're dependent upon you. And what I can tell you, even when they become adults, they're still gonna be dependent on you. So you're gonna have to start making better decisions if you truly love your child. You understand? All right, good luck to you, okay? In this court, communication is key. If there's an issue, let probation know about it. If you feel they're not addressing it, you can always come back and address it with the court, okay?
Thank you, Your Honor.
All right, you're welcome. Good luck to you.
Please.
Yes, he'll need to talk to probation.
Well, that was a fairly convoluted and bizarre situation. Speaking of convoluted and bizarre, let's go to Miami-Dade, because that's pretty much all they do there. Let's see how Judge Glazer's holding up as we're about a half an hour away from lunchtime.
They found 4 grams of cannabis, another gram of cannabis, a pipe with residue. So there's probable cause for count 1, possession of cocaine, $1,000 bond. Count 2, possession of drug paraphernalia is $500. Count 3, possession of cannabis, ROR. Have a good day. Next is Jeffrey Zelaya. Morning, sir. You were arrested for battery with a prior conviction. I will appoint the public defender's office for you. It's from April 1st of 2022. Are you currently together with Katia Lopez?
No, ma'am.
All right. So there's probable cause for the charge. You are ordered to stay away from Katia Lopez, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, her home, school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department, and file a receipt with the court. Do you understand the stay away order?
I do.
All right, your bondsman is here, so I'll set a bond.
Judge, I'd actually find public cause for simple battery.
So why is that? It says it's his prior theft, battery conviction.
Oh, because I see a battery withhold.
Oh, but it happened after the incident, Ms. Quarry?
Right, the withhold's from May the 11th, 2022. This incident's from April 2022.
Okay, probable cause for battery. His bondsman is here. The bond is $1,000. Have a good day. Next case is Dante Noble Sinclair. Good morning, sir. You were arrested for grand theft of a vehicle, trespass to an unoccupied structure or conveyance, contributing to the delinquency or dependency of a minor, and petty theft. I will appoint the public defender's office for you. Let me take a look at this. So he's a driver of the vehicle. Juvenile in the front passenger seat. Vehicle was reported stolen. So I guess there's probable cause for count 2 because he's in a stolen vehicle. You want me to split 1 and 2? It's 3rd-degree felony, grand theft.
That's fine.
Any objection to pretrial? He's
It's
eligible for pretrial? I know
okay.
he was resisting. He wouldn't get out of the car, but it's all right. Count 1, it's gonna be pretrial services, alternate bond. Count one will be $2,000. Count two, trespass will be $500. Count three, contributing to the dependency or delinquency of a minor. I'll set that at $1,000. And count four, petty theft, it's $150. Have a good day. What's the petty theft? I'm sorry, is it a tag? Oh, sorry.
So she seems to be holding up all right. Michael with his eagle eyes, which is just hilarious considering Michael's sight issues, but he spotted that she's back in the other courtroom. She actually started the day in her regular courtroom, and then they went offline for about a half an hour, so I think she's still having audio and equipment issues in that courtroom since their upgrades have like totally failed. But we'll keep an eye on her. Let's go back to Judge Stevens, new contestant.
Everybody would be denying it, but the point is that we're doing the tests, and either we're going to rely on the tests or we're not relying. We've only relied on them for 15 years. They just go through record on them. And I feel sorry for kids. Dasha Dugas. Ms. Dugas is here. She's got 2 cases, and she is working on trying to hire him. That's what it was and asking the court to give her a little time. Is that what you want to do? He's a fine lawyer, but you can go hire some people. You are charged with two motions to revoke. No, there's just one. A new case, I guess, is the burglary of a habitation, which is alleged as paragraph 1 here. All right, this is the 1830538 that you were on probation for is assault, a 3rd-degree felony, assault on a public servant. Burglary of a habitation is the new case, which is a 2nd-degree felony. If convicted, face up to 20 years in prison. The motion to revoke probation on the earlier case alleges you've committed burglary of a habitation as a violation of probation. Failed to provide verification of performing community service hours and failing to pay court-assessed fees by being in arrears over $6,000 as of June 27th. He's your attorney right now. You can go hire somebody, but I want this motion to revoke probation hearing in 2 weeks.
Everybody all right?
You either be ready or not, but in 2 weeks, you can hire somebody but it's not in front of a jury. It's in front of me only. We're going to resolve this. We're not going to lollygag. And I'm setting it in 2 weeks. Hearing on that burglary, on that motion to revoke probation, and on this one, as you probably know, if convicted, you're looking up to 10 years in prison. Okay. That's what we're gonna do. And if you hire a lawyer, they have to be ready in 2 weeks because I'm not waiting. We're moving forward. Get it resetting. And thank you. Okay, Dwayne Francis. Dwayne Francis.
Again, something to go with. Judge, he's in this process.
I saw Mr. Paget out there.
They're on. Good morning.
Dwayne Francis, we have Three cases. Four cases. Oh, boy. Okay. Here we go. You are Dwayne Joseph Francis, right? Okay, you're charged in 4 indictments. In 24 CR 1437, the 3rd-degree felony of evading arrest or detention with a motor vehicle, carrying with it up to 10 years in prison. In 24 CR 1438, you're charged with the state jail felony of theft, which carries with it up to 2 years in the state jail. 25 CR 69, a state jail felony of theft, which carries with it up to 2 years in the state jail. And 25 CR 70, the more recent case, that's a theft and carries with it up to 2 years in the state jail. Is there something about thefts that you're hooked on right now? Let's see. It says here in 1438, a mulching head was stolen, which is a value of $2,500 or more from Drainage District 6. Then was sold. A Dodge automobile was stolen, according to indictment 25 CR 69. And here's another Dodge automobile. Stolen. All right, so all of this looks like it's up to 16 years in prison for all of these. That's the potential you're looking at. What do we do today?
Your Honor, he's given out this weekend. I have a relationship with him. I can tell you this. He works a full-time job. He's very productive. I can't speak on
his honesty.
Well, I can only tell you what I know.
I know what the grand jury thinks. Okay.
I understand that, Your Honor, but I'm just telling you that he is a taxpayer. He does get up and work a full-time job every day. And I can tell you a little bit more about these once he hires me and I dive into it. And I assure you that I will. If you will just give us a standard reset, I assure you I will not drag my feet. We'll get this recovery and we'll move forward on this case quickly.
Okay, what's the total amount of restitution? Do you know from Stan?
I believe the majority of the items were judge.
That's my understanding, but again, I don't.
The only one I showed was $195. All the rest of them, all the restitutions are for. That's what I've shown my notes. So
that's what my client told me, but again, Your Honor, it'll just give me a little bit of time to dive into this, just a standard reset.
There's nothing standard in this room anymore. I'll give you 5 weeks.
That 5 weeks will be plenty. If he does what he says he's going to do, he'll hire me this week and then I'll have the motion filed on Monday.
Okay. Anything else? That's all. Thank you. Get a reset. Thanks, Mr. Patterson. See you.
Well, you're going to see me quite a bit. It looks like it because this is my last case.
Sam Hodges.
We'll just make up on each other quite a bit.
Sam Hodges had 4 cases at this point, huh? Yes. What are we doing?
He had an attorney in Houston who was representing him, who withdrew.
I think I need Sam Hodges files.
I believe you allowed his prior attorney to withdraw. And he tells me that he is working on hiring someone here locally to handle it. That's really time.
We're not waiting. Look, this 22-40933 was indicted 3 years ago. I'm not waiting.
Judge, the bill number 23 DCCR 2252 is a robbery. That case has been on the trial docket. The state's been ready for that. I've asked if there's any reset that it goes back to the trial for that case.
Are you represent?
I've never met him until today. But he was represented by his attorney in Houston. He tells me when I met him this morning, he tells me he's working on getting somebody.
You can do it. We're going to try it. Mr. Deucer here. We're going to pick it up and try it again.
There is an.
And we can. You got to get a lawyer involved, or he will handle it one way or the other. But we're not going to. This is way too old. These are way too old.
Also, there's an underlying concern as to whether or not his bond conditions are appropriate because we picked up 2 additional charges this year while that robbery case was pending under bond.
Okay. So 22-40-933 is the oldest one. And that's a state jail felony of engaging in organized criminal activity. And the indictment shows 5 prior felony convictions dating back to 2007. Looks like that state jail felony is going to be punished as a second-degree felony.
That's correct.
So he's looking at 2 to 20 on that. Then we've got a robbery, second-degree felony robbery with a prior felony possession alleged in paragraph 2. So that's a first-degree felony punishment.
That's correct, Judge.
In 23 CR 2252. Yeah. And that was an indictment handed up on December 23. And we have 2 newer indictments here handed up by the grand jury on August 13th of this year. Burglary of a vehicle committed allegedly on or about April 10th of 2025. Also April 10th of 2025, a second indictment, burglary of a vehicle, both state jail felonies.
So, Judge, even though they're styled burglary vehicle, these are the nature of a jugging offense where the defendant, along with someone else, spotted someone getting money at the bank, followed them, and then gets their money when they step out of the car. So they take the person out of the mix to avoid the robbery that we're dealing with. And the other calls them, they wait till the person leaves the car, then they go and get the money out of the car. They did that in Beaumont and Needham, and that's these 2 charges on that same day.
What are you asking for?
I need this bond addressed because apparently I know one of the conditions is that we're not committing any new offenses, and apparently the bond of whatever amount it is isn't sufficient enough to give Jefferson County any kind of.
What is
state
the bond?
That I don't know, Jeff.
240933, the bond is for $24,000. On the 23 DCCR 2252, the bond is $40,000.
Who ordered that?
Yeah.
As I'm looking at, among other things, the public safety report in these files, which clearly show
Just the $40,000 bond.
2 full pages of arrests and convictions, 15 on each page. So those are considered, certainly by this court, by law, any magistrate's supposed to be reviewing those.
Yes, sir.
When they're setting law, or you get in trouble. Yeah.
The $40,000 bond, it looks like we set that after a possible positive drug test.
What date?
That was October of 2024.
29.
$40,000 was a drug test. And then the older pay.
No, hold on. All about the 2 new cases. There's no way I did that. These 2 new cases weren't indicted until August of 25.
So Judge, the $50,000 is on the robbery case.
Oh, you're talking about the initial thing?
Yes, sir.
Okay, all right.
So we set the bond
Okay.
of 40,000 and 24,000 in the robbery and the engaging in organized criminal activity.
Yeah, I'm talking about the new burglaries. That's all I'm.
The new burglary cases, he has bonds of $15,000 in 1022 and $6,500 in 1023.
Who said that?
Okay, let me look. Yeah.
Because there are public safety reports in these files that show the criminal history, which, anyway, just. All right. You know what's about to happen? No, not on this watch, this court's watch. You're gonna be charged with felonies, including violent crime, robbery, and then thereafter, while you are on bond on those two, shortly after you're placed on bond, you're gonna go out and commit more crimes. All of these bonds on each of these 4 cases are raised to $100,000 each.
Thank you, Judge.
You will be at home confinement. I can't trust you leaving your house. You're gonna be home confinement. Plus, you have to have a GPS device, so I know where you are at all times when you're not committing crimes. And when you're committing crimes. 4 of these. It wasn't enough. It wasn't enough. And we made a big deal on these first 2 cases, warning you of the seriousness of all of this. So you quite naturally go out and commit more felonies. That's the way the law works. When you commit more felonies, everything goes up in price. It's as though you're completely ignoring the rules. And if this is true, where you're doing what's called jugging out there, those are serious infractions. And that's organized crime. And that has even higher punishment ramifications. So if you go out and you can hire a lawyer, but until then, he's your attorney. What are you announcing right now, Don? It was an announcement. Okay, I'm gonna reset this 4 weeks. Thank you. Everybody start getting ready for trials.
Yes, sir.
Sharon Lee, please. You're in custody.
You should have a notice of representation from Lane Walker.
How many cases do I have? 2 cases? You're Miss Lee? Is Mr. Walker here? Have you hired him?
Yes, sir.
You've already done that?
Yes, sir.
Did he know about being here today?
He said
He said he was gonna be here?
he said he texted Ellie
Uh-huh.
or emailed Ellie.
She confirmed with me that she has a representation letter.
See, the thing is, it says the last event in the file is in the process of hiring Mr. Walker. I wonder if all the papers have been.
She told me it came in this morning.
Oh, maybe it just didn't process through. But Ms. Lee, I can't tell you enough about how serious these 2 cases are.
Yes.
These are both first-degree felonies, which are rare for money laundering and thefts of property. Rare first-degree felonies, which means the values of what was taken is enormous, according to what the grand jury alleges.
Over $300,000 worth of restitution is owed, Judge.
In each case is what it's being alleged, but you're facing no less than 5 nor more than 99 years confinement or life imprisonment, and a fine up to $10,000 can also be assessed for each of the 2 cases. So that's 2 life sentences $200,000. Okay, that's what you're looking at. I'm gonna set this for an announcement in 4 weeks. And I guess we'll send it to Mr. Walker, who's apparently the person who is going to be representing the defendant. Get a resetting, man. Thank you. Justin Moore.
Chief, your clerk got a notice this morning of verification.
I gotta say, the possibility of a life sentence for something like that is amazing, considering Elizabeth Holmes, for all the hundreds of millions of dollars she frauded people out of, didn't get anything even close to that. Just saying. I guess they don't like financial crimes in Texas. Let's stay in the building, but we'll go across the hallway to Judge West.
Next week, Mr. Matuska, Mr. Nichols did mention to me this morning an issue.
It's with scheduling. The DNA was sent out to a private lab, and they were requested a little more like a month or so ahead of time notice, and I only gave them a few weeks, and they said they wouldn't be able to schedule.
Okay.
So I'm asking for a reset for that.
And that's a private, it's not the normal lab
It's
that we
not
use?
DPS, it's a private lab that was used to expedite testing in this case.
Okay. Obviously, we need that, I would think. Okay, so what I'm going to do is I'll reset it to the next trial docket. Obviously, at that point, it'll be time probably to get it done. That'll give you plenty of time to get with them, now that we know that issue. And so we'll get that taken care of and get it on the next trial docket. Okay, thank you. Goodbye for the bailiff. Is Mr. Samuel here, Oddman Samuel? Oh, yes, I'll hold your case. And Mr. Wilkerson, it looks like you've got a tablet out. Are you working on paperwork on Mr. Johnson?
No, Your Honor.
Okay, Romeo Johnson. Morning.
Morning.
Morning. Good morning. Are you Romeo Johnson? Yes, ma'am. And this is cause numbers 24 DCCR 2095 and 2419. Mr. Johnson's cases are set for trial to begin with jury selection next Monday. What is the announcement?
We're ready, Your Honor.
All right. Anything that change in negotiations that we need to go over today?
I was given some additional discovery materials, but it's just a complete autopsy.
Okay.
So there's no new offer or anything for me to present to my client.
I'll entertain a counteroffer.
All right, if y'all want to visit this morning, just to double check if there's any counteroffer or anything like that, let me know. I'll hold it for a minute. Otherwise, it'll get numbered for trial.
Yes, Your Honor.
Okay, thanks. Mr. Galmore, you've got Ronnie Green.
Good morning.
Good morning. Good. How are you?
Pretty good.
Let's see here. And this is for, you're requesting bonds on the two motion cases,
Yes.
correct?
He's on deferred on 2 different cases.
There's also additional fees.
Thank you. I'll pull that up now, Mr.
I'm just really asking for a setting on those additional files.
Okay. Oh, okay. Okay. Good morning. Are you Ronnie Green the third? And Mr. Green, we have 23 DCCR 1502 and 24 DCCR 1320. Mr. Green is on probation for possession of a prohibited weapon and possession of marijuana. Motion to revoke probations have been filed in those two cases. There's a new indictment in cause number 25 DCCR 0735. Mr. Green is charged with money laundering. Mr. Galmore has filed writs asking that I set bonds in those 2 MTRP cases. He is on deferred probation, so generally entitled to a bond, but based on the nature of those offenses and that new offense, I wanted to have a hearing and get the state's input on their position on bond amounts, and bond conditions.
The state's filed a reply to the writ that was filed by Mr. Gilmore. I don't know if you had an opportunity to see that or I've kind of laid out the state's argument.
Okay.
In that reply.
Let me look at it
I'm happy
real
to read
quick.
that.
I feel like I might have seen it, but I've slept since then, so give me a second to.
Judge, I don't know if you see letters in there as well. There's been letters that have been supplied to the court.
Okay, I'll take a look at all of that. I don't know. Do I have any of that over there? Anything printed out on him? Some of that sounded familiar. Yes, okay, so I saw the letters.
Yeah.
I can summarize it for you, Judge.
Okay, the letters I got. Brandon, let me look at this real quick. Now this is looking familiar as well. Oh, yeah. And I recall now what you filed also with regard to some requests, and we'll get that set for the appropriate time, Mr. Coleman, as far as modifying bond conditions and things like that. And I guess you've seen those.
I've seen that.
I don't know if y'all want to talk about that, if there's some agreement or not, but for this morning, Mr. Galmore, I guess you can just make argument or.
Yes, Judge. I would just like to summarize a few things real quick. He is on probation for 2 cases. They are different offense dates, but I want to point out that he did not receive probation and then pick up a new case. These were the situation where he received probation and there was an older case that just simply not been filed yet. Since he's been on probation, there has not been the commission of any new offenses other than the offenses we're talking about today. I will say that he's been in jail for 20 days, which is longer than any other time that he's ever been arrested before. I did have discussions with the state today about a possible resolution that would involve Mr. Green going to ISF and not revoking his probation. And that sounds like a reasonable outcome. I have not had an opportunity to review the discovery in the new case, and so I don't feel like I'm in a position yet to advise my client on what would be the best option as far as that's concerned. I would point out that in the letters, there's one thing that really kind of struck a chord with me, is that since this alleged offense of the money laundering, which was earlier this year, Mr. Green has really taken a lot of efforts in his life to start walking the correct path. He became more involved in his church. He was baptized since the alleged commission of this offense. He's got a lot of family support. His mother is here in court today on his behalf. And so what we're just simply asking the court to do is set reasonable bonds. He is on deferred. And even though there is a new offense, I would say that the majority of all motions to revoke probations are based on illegal activity. Even if it's not a new offense that was committed, it's alleged. Very common is a failed drug test, and obviously if you're failing a drug test, you're committing a crime at some point, possessing that illegal drug. And so we're just simply asking the court to set reasonable bonds. I believe reasonable bonds in this scenario would be about $10,000 on each case. I believe the government is asking for $50,000 in their motion.
Your Honor, and Mr. Galmore and I agreed that we were both asking the court to set reasonable bonds. My version of what's reasonable, given the fact that less than 1 year since the defendant was placed on 2 deferred adjudications, he's out allegedly committing money laundering. If the allegations are proven true that money laundering, those proceeds constitute proceeds from drug trafficking or delivering controlled substances, Judge, The opportunity, as Mr. Gallo put it, to walk the right path, the correct path came back in 2024 when this court put him on probation for possessing a weapon that was outfitted with a Glock switch. My version of what a reasonable bond should be in light of this defendant's actions is no less than $50,000 in each case.
So if there is well, two things with regard to what you're talking about. One is, depending on whether or not the allegations were proven true, and if there was some thought of continuing Mr. Green on his probations and getting a probation on that new case, the only way I would go along with something like that would be for ISF, some type of cognitive program in custody. And while I understand and appreciate that he's making some strides on his own, from a legal standpoint, it doesn't make a whole lot of sense for him to be back out and then go right back in to ISF. The point of ISF is to get that done so that when you get out, you've got better tools to make better decisions so that you don't end up in prison for, I mean, you're looking at prison up to 10 years on those two cases, and then you've got the new money laundering case. So
To address that, just real quick, Judge, the money laundering case, I've only been on the case for approximately 2 weeks.
Right.
In speaking with Mr. Green, he states that he does have proof for a lot of the money, so I don't think at this point I can even advise him that agreeing to a deal where he goes ISF when that's the only violation is the appropriate route. Of course, with him being in jail, it's a lot harder for him to assist in his own defense of that case.
And Judge, of course, the state has a different position on the proceeds or where those funds were derived from and our ability to prove where they came.
Let me look at something real quick. I guess I'm just taking a look at the probable cause affidavit on the money laundering, just to get an idea of what those facts are. I think I have a little bit of them from the facts, obviously, from Mr. Coleman's response to your request, but let me look at this real quick. Actually, I can't read it. I'm printing something. Maybe.
Maybe.
It's a long way for it to go from here to there. Okay, how long, obviously you need some time, Mr. Galmore, but how quickly could you get up to speed on the money laundering?
It wouldn't take me very long to get up to speed on the discovery and watching the videos, but it'd be substantially more difficult to try to track down financial records for Mr. Green while he's incarcerated in the Jefferson County Jail, which is one of the reasons why we're asking for bonds, so they can assist in that part of his defense.
Your Honor, I would offer this. When interviewed by the law enforcement, the defendant indicated that he had no records that would show the source of the proceeds that were received.
That you're correct, that's what I see as well, other than maybe one social media post on Instagram.
It appears on the roadside discussions about the sources of money that Mr. Green did not have a lot of answers necessarily, but I would say that on the side of the road, the question about.
Well, I think they brought him in and Mirandized him, right? Once at the jail, read Miranda warnings, waived his rights, and during the interview, couldn't explain how he obtained it, advised he sold one French bulldog late last year for $1,500, but nothing else. Didn't have a job. One Cash App thing he could show for that one dog. So.
I haven't seen that video
Yeah.
yet. I'm assuming it's video recorded, it's posted.
It should be, yeah.
I just haven't had an opportunity to review that video. I do know that there was a car wreck where he received a settlement from that car wreck, so there were some additional funds that weren't discussed. But again, I don't have access to those records as of yet.
Okay. All right, so what I'm gonna do is grant the relief requested in 23-1502, set the bond in that case at $35,000. In 24 DCCR 1320, also set the bond at $35,000 in that case. I'm going to order as a condition of both of those cases that Mr. Green remain in Jefferson County, also that he wear a GPS monitoring device at all times, and then we will reset the case for a status at just in normal 30 days or so. Okay.
The court believe or think that a curfew would also be appropriate?
He's on probation, so he has a curfew.
All the standard conditions.
All the standard, you're still on probation, so if you make these bonds, all your regular conditions apply, but now there's the GPS monitoring device and a remain in Jefferson County also as a condition of your bond, not just your probation. Okay? All right.
Thank you, Judge.
Okay, guys, we're going to move over to Judge Boyd, but just an FYI, I've got my eyes on some potential breaking news. Joint Base McGuire-Dix Lakehurst in New Jersey is on lockdown. Possible shooter there. Not a lot of details, so we'll keep an eye on that. But let's go to Judge Boyd.
All right, State, are you ready?
Yes.
All right, the court is calling 2025 CR 004887 State versus Juan Alberto Martinez. Could I have parties announce?
Megan Galloway for the state.
Robert Featherston representing Mr. Martinez.
And are you Mr. Martinez?
Yes, ma'am.
All right, first things first, defense, you requested a PR bond for your client and the defendant was to be interviewed. Is that correct?
That is correct, Your Honor.
All right, the court is in receipt of the interview report. State, have you had a chance to review it?
No, Your Honor.
All right, if you'll pass that to this one. Right, thank you. All right, defense is your motion.
Thank you, Your Honor, by way of proper. Judge, Mr. Martinez has no bank accounts, no personal property.
Sorry, just a moment. Excuse me. If y'all could wait, we're on the record. Counsel, you may continue.
Thank you, Your Honor. No personal property of note, no vehicle, no boats, no real property. He relies on his mom down in Laredo. His home is in Laredo. Judge, the court does need to know that there was a violation report on May the 13th for failure to take a drug test while he was down in Laredo. Judge, the testing agency down there in Laredo demanded $75 from him that he just did not have. And was unable to get his testing completed. Judge Castro went ahead and increased his bond to $25,000, and he's been in custody ever since and being picked up for that bond increase. He was originally given a PR bond back on February the 26th of this year by Judge Navra. Very respectfully requesting that the court consider putting him again on a PR bond and allowing him to reside in Laredo during the pendency of this case. Any possibility of giving Mr. Martinez a break on any drug testing charges would be appreciated if this honorable court were able to do so. And I thank the court for its time.
All right, state.
Yes, Judge. So I would just ask you to take judicial notice of the court file, but I just want the record to be clear. The defendant was granted a PR bond on February 26th of 2025 in the amount of $10,000. And he bonded out, and then he received the violation report on May 13th of 2025 for non-compliance, and that was for failing to complete the random drug vaccine. And then after reviewing, I guess, defense's exhibit of the PR interview, it would appear that the defendant proceeded to pick up 2 new cases in Laredo, Texas, while he was on bond. And so given those facts, I think he's a flight risk based on what I read. He has sufficient ties to Laredo, and it appears like he has family that lives down there. And I guess if he was living with his family, that family, when he picked up those new cases, I don't think that that's a good environment for him to return back to. Additionally, give me just, I think the record is clear that, I mean, the PR bond is not sufficient for him to appear in court because he was previously been granted one and did not appear after that violation report. That's why the warrant went out. And I don't think he was picked up again until he was booked in Laredo and then extradited back here. So we believe that the bond is set and is sufficient, and I would also offer State's Exhibit B1 for purposes of this hearing.
All right, have you?
No objection for purposes of this year.
All right, then states B1 is admitted for purposes of this hearing only. Just give me a moment to review.
Thank you.
All right, the court has reviewed states exhibits B1, and the court has reviewed the PR bond interview with pretrial services. Any response to the state's argument?
If the court will allow.
Yes.
Judge, there really is no evidence in front of this court with respect to flight risk unless you consider Laredo itself to be a flight risk. But there's no testimony that he had connections across the border. There's no testimony that Spanish is his principal language. really, the only issue with respect to flight risk would be to say that his principal residence is Laredo.
Mhm.
He has two new allegations against him, but they're allegations down in Laredo. If the court grants a PR bond here, he has to go back to Laredo to answer those new allegations. So that he'll be transferred by the state back down to Laredo to take care of those particular issues. Should have nothing further.
All right, thank you. All right, after reviewing state's exhibits in the pretrial services interview for a PR bond, the motion for, or the request for a PR bond will be denied.
Okay, thank you, Your Honor.
All right. And then are you all ready to take up this other motion?
Judge, I need more time to get with my office to see if we have the resources to do what's outlined in the CCP, or if we need to do the in-court. So if I could have a little bit more time on that.
And so counsel, the court understands that whatever the state's resources are, there or lack thereof, doesn't play a role in the court's decision on what should be granted. Like if there's not funding for something, I'm going to follow the law, whether there's funding or not. So
thank you, Your Honor. With respect, well, two things. With respect to the bond hearing today, would the court reduce his bond from 25 to a different figure of?
No.
You want to keep it at 25?
Yes.
With respect to the identity hearing, Judge, we would like to have the identity hearing as quickly as possible, pursuant to the court's calendar. And also in my motion, I requested a protective order that the detective that's the subject of the identity hearing not be shown any booking photographs of Mr. Martinez until after either an in-court lineup is done or the Code of Criminal Procedure 7 photo lineup.
all right, well, let's do this. Let's have you, if you'll confer with the state on a time to have this hearing. And then if you all approach the coordinator and let me know what time you all have agreed upon, and then we will set it and we'll have it.
You're most kind. Thank you.
All right, thank you.
Just one question. Do you want that hearing like around the jury trial, like we're doing it on Monday and beginning the jury Tuesday?
We could do it that way, because I know we haven't set a jury trial in this case. I mean, a jury trial date.
That's correct, Judge.
Because their final discovery is October 20th.
That's correct, Judge. And the issue is now, he can't make his bond.
Okay.
So he remains in custody. However, if we get an identity hearing done as quickly as possible, it may turn out that the state is going to dismiss this case based upon the results of the identity hearing. Conversely, if the identity hearing does not go his way, it may end up in a complete.
Well, let's do this. With regards to the identity hearing, it will be no later than October 20th.
Thank you.
But if you all are able to come to an agreement to have it sooner, then we'll have it sooner. But at the latest, October 20th, because you're already set here in the court on October 20th for discovery.
Does the court have a preference as to whether it would be a in-court live lineup or whether the photographic procedure would be sufficient?
I'll let you confer with the state, because they're saying there may be some resource issue. So maybe if you confer with the state, maybe y'all come to an agreement that it's a photo lineup if I grant your motion, or y'all may say in person. I don't know if they can find people in person. It's sort of, it reminds me of the episode of Brooklyn. What is it? Brooklyn Nine-Nine?
Oh, yeah.
Where they do the lineup. And when they do the lineup, the lady says, I just remember them singing that way. And so he said, everybody sings a note. So I don't know if they'll be able to find people to come in for a lineup. They may only be able to do it by photo. Well, unless we have some actors. I don't know.
Judge, I understand that. Years ago, in Travis County, we had to do a pickup jury where the the bailiffs went out in the hall and just found people, pulled them in, and then they became jury packs.
Oh, wow.
So, we have that option here if necessary.
All right, well, just let me know. And if you all get together and give me an idea of when you all want to do that. And as I said, Mr. Martinez, the latest will be October 20th.
Thank you, Your Honor.
All right, thank you. Thank you, counsel.
All right, update for you. The lockdown at that joint base in New Jersey has been lifted. That lockdown only went on for about an hour, so that implies to me that whatever happened there was probably a false alarm. But if there's more details, I'll pass it on. Let's go back to Judge West.
Mr. Kane was previously found not competent to stand trial, sent to the John Donne Behavioral Science Center for Competency Restoration, received a packet from them dated September 15th of 2025. It includes the attending physician's report to the court from Dr. Liberis with the opinion that he is currently competent to stand trial. In addition, there's a trial competency evaluation report that was prepared by Dr. Robinson. Also has the opinion in that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor. No, Your Honor.
All right, then at this time, based on the two reports, I am going to find that Mr. Kane is competent to stand trial. Mr. Rojas, will he waive the formal reading of the indictment?
He will, Your Honor.
Mr. Kane, in cause number 24 DCCR 1947, the state's elected to proceed on the lesser included offense of a Class A misdemeanor evading detention, and that's from August 9th of 2024. And how do you plead to that charge?
Guilty.
Okay, and are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, I did.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, Mr. Kane, I'm going to find again that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor evading detention. Sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff.
All right, well, she brings up the next contestant. Let's go back to Judge Simpson. His court has been spirited today.
Take that option here.
Yeah, I knew that. Good morning again, Judge. Today is the date and time scheduled for a probable cause conference. Mr. Gerard will waive his right to a preliminary exam today. He has executed the written waiver. You should have that in your
Sir,
file.
you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and you committed them?
Yes, Your Honor.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right?
We do.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 following. As to the circuit court arraignment, you acknowledge receipt of the information, waive its reading?
So acknowledge waiver reading of the information, Your Honor.
And how does your client plead at this time?
Please not guilty.
Defendant having waived formal reading, pleading not guilty to all 3 counts, court will enter that plea. Pretrial will be set for
December 3rd at 1:30.
December 3rd, 2025, 1:30, Judge Conlon.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case People versus Robert Gallet or Gallup.
Morning, I'm Robert. Oh, well, Judge, I'm on case 25 F5 5612.
Assistant Public Defender Elsie Vergils with and on behalf of Robert Gallet.
State your name, please.
Robert Gallet, also known as Lynn, sir.
Thank you.
You're very welcome.
What are we doing?
I believe we would like to set a preliminary exam in both cases.
Correct.
Discovery complete in both cases?
Yes, Your Honor.
Yes, Your Honor. Information.
People have their witnesses available on the 14th or 16th. No, 14th, I'm sorry.
I believe so, Your Honor. Judge, can we go the next week? I'm sorry, I'm not my first vacation.
Are you held on anything else?
Yes. I believe Ms. Gallet is being held. So the case that I have her with is a $10,000 bond, which is holding her $100 on Mr. Kilowald's case and then $100 on a misdemeanor in 15th District Court.
Bottom line, is there any objection to going to the 21st?
No, Your Honor.
Thank you, Judge.
Preliminary examination in person, October 21st, 2025, 9 a.m. That is before. Is that noon? Can be.
9 a.m. 9 a.m.
Is it before me?
Yes.
9 a.m. before me. Bond will continue. Thank you.
Thank you, Your Honor.
Thanks, Judge.
Court calls case People versus Donovan Friel.
Good morning, Your Honor. Samuel Bennett, bring with and on behalf of Mr. Friel, who's appearing via Zoom. We waive our in-person appearance.
Friel,
Yes, sir.
state your name, please.
Donovan James Friel.
Thank you. What are we doing?
Your Honor, I'm just looking if we can set an exam date for that 14th of November. That would be perfect, please.
Well, is discovery complete?
Yes.
People have their witnesses available the 14th.
We'll do our best, Your Honor.
Preliminary examination in person, October 14th, 2025, 9 a.m. That's before Judge Valvo. Bond
you very
will
much, Your Honor.
continue. That is in person. Bond will
Absolutely.
continue.
Thank you, Your Honor. Have a good day.
Thank you. Court calls the case People versus Richard Halstead.
Andrew Banis for the people.
Mr. Byrd? No, it's okay. Sorry to wake you from your nap.
Brandon Byrd on behalf of Richard Halstead.
Thank you. Your name, sir?
Richard Halstead.
Thank you. What are we doing?
Respectfully, Your Honor. We were trying to work out a deal last time. I just asked for a slight adjournment if possible.
Probable cause conference will be adjourned to October 9th.
And permission to address bond to you.
Briefly. 9 a.m. That's at 9 a.m. Yes.
Respectfully, Your Honor, my client was in contact with me last time. Truck went down when he was trying to get here. He did try and contact me. You gave him a 48-hour warrant, but he contacted me a little bit later than after that 48 hours. But I'm just asking.
How did he come back into custody?
Last Tuesday.
Pardon?
Last Tuesday, I turned myself in.
Why didn't he appear?
his truck went down, Your Honor. When he tried to, when he tried to get here.
Any response from the people?
Your Honor. We'll leave it to you. I do not have any thoughts.
Previous bond is reinstated.
All right. Instate.
I'm sorry.
Fine.
Motion is granted. Court does call the case of the people versus Brandon Kelly.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Kelly.
Mr. Kelly, can you state your name, please?
Brandon Kelly.
Thank you. What are we doing?
Mike Gaddy for Mr. Kelly, Your Honor. Your Honor, having a chance to discuss this matter with Mr. Chablowski and with Mr. Kelly, I think we want to set this for an exam today.
Discovery is complete.
Yes, Judge.
People have their witnesses available the 14th.
Yes.
Preliminary.
90 days in jail for one punch. That's how long I've been in here.
All righty then. October 14th, 2025, 9 a.m. That's before judge, and the record should, well, he hasn't left the room. Record before who?
Washington.
Judge Washington. Bond will continue. Court calls case people versus Gavin Porter.
Morning, Your Honor. Alex Warren Green on behalf of Mr. Porter. You state your name? Gavin Porter, Your Honor. Your Honor,
so go ahead.
I completed a green sheet. I would be requesting an adjournment so that retained counsel can
finally give us an appearance or a substitution.
That's correct, Your Honor.
My office is notified twice what he needs, and it's inexcusable that he doesn't have it.
And
probable cause conference will be adjourned to October 16th, 2025, 9 a.m. Bond continued.
Here, it's okay. Thank you. Appreciate it.
Court does call the cases of the people versus Montel Gatlin.
The public defender, Tanaka Carey, Your Honor, on behalf of Mr. Montel Gatlin, who is approaching. Today is the date and time set for competency evaluation. I have a receipt of the report. Does the court have it?
What's the date of the report?
I apologize, Your Honor. Sorry, Judge, I have to pull it out.
Do the people have a copy of the report?
No.
So that's true.
Oh, sorry, Judge. Actually, I apologize. It was mislabeled. September 12th.
That sounds perfect.
And I want to review or no?
Well, the last report I have is July 12th. It's gonna have to be emailed over. We're gonna have to take it back.
Okay.
I'll have to review the report. Somebody get me a copy. I'll look at it and
I'll send it
back
right
out.
here.
All right, Mr. Gatlin. Court does call the case of the People versus Jacob Ramsey.
Andrew Banish for the.
Morning, Your Honor. David Chan on behalf of Jacob Ramsey, who's approaching.
Your name, sir?
Jacob Ramsey.
Thank you.
Your Honor, we're going to waive the preliminary examination.
Sir, is that correct? You're waiving your right to a preliminary examination?
Yes.
You understand that it's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir. Yes, Your Honor.
People also waive their right.
Yes.
Preliminary examination, having been waived, defendants bound over to circuit court on the single count. Mr. Shand.
We will waive formal reading of the charges. Defendant will stand mute.
Defendant, every way, formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for November 25th, 2025, 1:30. Judge Kunke.
Thank you, Your Honor.
Thank you. Bond continued.
Thank you, Your Honor.
Court does call the case People versus Emmanuel Hunt.
And Lisa, on behalf of the people, Your Honor.
Yes, ma'am. Vernon Bird on behalf of Emmanuel Hunt. Mr. Hunt, can you please state your full name for the record?
Andrew Julius Hunt.
Your Honor, we'd like to set this matter for exam.
Do you also want a hearing on this bond violation?
No, Your Honor.
He admits to it.
He admits to it.
How long has he been in?
Almost 30 days now, Your Honor.
And his arraignment date is 9/7.
Gotcha. Sentence on his bond violation is 14 days. Credit 14, sir. Discovery is complete. I'm sorry, counsel.
As far as I know, Your Honor.
People have their witnesses available the 14th.
We'll do our best, Your Honor.
I need you to do me a favor on that. Yeah. Preliminary examination in person, October 14th, 2025, 9 a.m. That's before Judge Valvo.
Thank you, Your Honor.
Thank you.
You, Your Honor, have a great.
The same, sir.
Thank
Be well.
Thank you.
Court calls the case People versus Nicholas Smith.
Al Chabalowski for people.
Okay, good morning, Your Honor. Robin Kennedy appearing on behalf of Mr. Smith, and I am going to turn my video on here in just a moment. There we go. Thank you.
Thank you. Mr. Smith, can you state your name, please?
Yes, sir. Nicholas Smith.
All right, what are we doing?
Your Honor, Mr. Smith has the opportunity to avail himself of a reduction, but in order to do so, we are seeking out treatment courts, and he is not in Washtenaw County any longer. So we are searching for treatment courts. We're asking hopefully for just a last adjournment to have the application processes complete and to have an answer as to whether or not he would potentially be accepted into a program that would be local to him.
Without objection, probable cause conference, October 23rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Marcus Jackson.
Andrew Banish.
Assistant Public Defender Davi Liebel on behalf of Mr. Jackson. Your Honor, Mr. Goldstein has filed a substitution in this matter, and I believe he has stepped out. I would request.
Where?
I believe it's Judge Washington.
Do you have it?
It is in my file, Your Honor.
What?
I have a copy in my file, Your Honor. I don't know if it was
Okay, that
provided.
does me no good. Is it signed by me?
No, Your Honor.
We got it? So it's Goldstein's case. Do we know what he's doing? He's not here. All right, I'll pass. I'll pass it. I'll have to call him out later. Court calls case People versus Terrence Smith.
That order is for Terrence Smith. He should be on Zoom, Your Honor.
Terrence Smith,
I'm here.
state your name.
Terrence Smith. All right, I'm asking for an adjournment. I believe we were close to a resolution. We just got to facilitate a form.
October 9th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case People versus Mohammed Farah. AG's in jail.
Back on behalf of Mr. Farhat, who's to my right, please state your name for the record.
Mohammed Farah.
Christina Bate on behalf of the AG's office.
Thank you. All right, doing on this case.
Your Honor, at this time we are waiving to circuit court.
All right. Sir, you're waiving your right to preliminary examination. Yes, sir. You understand that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further proceedings.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
May I?
Your turn.
Oh, Your Honor, we waive formal reading.
And how does he
mute.
plead? Defendant having waived formal reading, standing mute, court will enter not guilty plea as to both counts. Pre-trial in this matter will be set for
October 15th at 1:30.
October 15th, 2025, 1:30 before Judge Conlon. And I'm sure the circuit court has how it's going to dealing with these cases in the event of shutdown. But that's the best date I have. All right.
Your Honor, may I just bond?
Yes, you may.
Your Honor, my client indicates that he does have a spot at Avalon Housing, and that spot will go away if he stays here. And also, he's been working in front of the court to secure employment, and he was able to with Michigan Works. So we ask that he be released.
You're asking that it be reduced. I don't need a response. He came in and he certainly turned himself in, and I arraigned him. I set the bond. I set it at the 25%. I don't have a justification for going lower than that, although those are all admirable facts. I don't think that constitutes justification or good cause to go lower. So it's set as low as I'm going to do it.
Thank you, Your Honor.
Motion for bond reduction is denied. Bond will continue.
Thank you, Judge.
Thank you. Court calls case People versus Joseph Spittler.
Good morning, Your Honor. Lawrence Margolis with and on behalf of Mr. Spittler. To my right, Joseph, please state your name for the court.
Joseph Spittler.
Your Honor, we are still in negotiations, and Mr. Kennedy has asked for a 2-week adjournment. No objection on my end.
Probable cause conference, October 16th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Okay, friends, we're going to go to Judge Boyd, but Beth has been kind of monitoring breaking news. We currently have 3 different colleges / universities across the United States that have had some kind of bomb threat this morning. Towson, Delaware State, and Lone Star College all have either had partial or full evacuations. All have had some kind of a bomb threat. So, yeah. We talk a lot here, especially in the pre-show, about team sanity and team insanity. So, join me here on team sanity because The world's getting weird. Anywho, on to Judge Boyd.
Back in school or studying?
Yeah, Ashley took the LSAT.
Yay.
Giving up to take it again. I'll tell you something. I think she did great, but she did the stars.
No, because do they still do that? I remember they said if you took the LSAT and then you did another one, then they would just average it. You can't just say, they don't do that anymore? Oh, you can take it as many times as you want to?
You can only take it 5 times.
Oh.
I'm not up on the rules, but I know the rules have changed.
I challenge all of us to take the LSAT again. It'll bring back memories. Bad memories, right? All right, so on this case, are we here on a motion to revoke? What are we here for?
We are, Your Honor. We're here on a motion to revoke, and I believe the state filed a motion to amend the motion to revoke, and it was filed on September 29th. Yes.
All right, just one second. Okay, there's nothing attached to this.
He said that the DA's printer hasn't lost ink and it was emailed to them.
I'll accept, I'm fine with service by email. That's okay with me.
Okay, all right, thank you.
I wrote it on there too, Judge. Email to the best.
All right, thank you.
We're working on getting the ink restored.
All right, thank you.
Hard time for the county judge.
All right, thank you. And then on Holguin, I don't have the motion to revoke file. Holguin. Oh.
Should be printed out there.
Right, all right. And so it's set for today, and what is the issue?
Your Honor, the first amendment was filed yesterday. This is the first chance I've had to get to talk to my client. I was wondering if I could have some time to prepare him and talk to him about this case.
All right, do you have the original motion to revoke? Because I only have the First Amendment. Where's the original?
Would a copy suffice?
Rashad is bringing it.
Oh.
Thank you. We made it. So the only thing that I see that's been added is a possession of a controlled substance.
Yes, Your Honor, that's one of the new number 1.
All right, do y'all have labs for that?
We do not. It just occurred.
Then labs, are y'all expecting to have those labs in 10
No,
minutes?
I told counsel there's no way we'll get those back anytime soon.
So then the First Amendment really has no bearing because they're not going to be prepared to proceed on the violation of condition of number 1, possession of a controlled substance. So I don't know why it was added. They don't have any labs for that. They're not going to have labs for that. And it'll probably be 6 months or whatever before they get labs for that. So really the only thing that's going to be proceeded on is probably the original.
The original.
Yes.
Can we go on that right now? Yes.
State.
May I see the?
Yes. And just let you know the one thing.
Sure, Your Honor, yeah. We, just so the court knows, on the original, the other new number 1, the evading, was dismissed by our office. So literally the only thing left is the number 2.
Okay. Do I have a file stamp, please? Yes. Is this a case that criminal trial division or is family violence going to handle? Because there's nothing that will be left in here that is criminal trial division. The evading has been dismissed.
Your Honor, my understanding before that was the discussion is that we were going to handle it, but I haven't conferred with family violence since.
All right, if you want to confer maybe with family violence, because it appears that the only thing on this motion is going to be failure to submit.
And we're going to plead true to it.
Okay. So I don't know if who's going to be making the recommendation on their side.
Your Honor, I'll proceed on.
All right, the court is calling 2024 CR 0077778 State versus Christian Grant Holguin. Can I have parties announce?
Melissa Albin for the state.
And Eric DeWalt, I represent Mr. Holding.
And are you Mr. Holguin?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, I did.
Are you the same Christian Grant Holguin who was placed on deferred adjudication in 2024 CR 007778 for the offense of assault family household member impeding breath or circulation on October 31st, 2024 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
You can proceed on number 2, Your Honor. On or about the 15th day of August 2025 in Bexar County, Texas, the defendant Christian Grant Holguin did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
State.
We'll waive the rest, Your Honor.
Any objections to the waivers?
Okay.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
May I speak on that?
No, my question is, do you understand
Yes,
that?
ma'am, I do.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
My understanding is there is not, Your Honor. The state is recommending that we follow the probation department's recommendation, which is to have the defendant submit to SATIF. We would withdraw the MTR and alter and amend its conditions for SATIF.
All right, so the MTR can no longer be withdrawn because he's
Oh,
already played.
That's right, Your
So-
Honor. I apologize.
No
But,
problem.
That's what we would recommend, is that he go to SATIF.
All right, so defense, what are you requesting?
Your Honor, exactly that. I just spoke to my client. He was under the understanding that he had a possession of drug paraphernalia when he did complete SATIF and does have a full-time job and understands he's going open to the court. He missed this one drug test because he couldn't get there on time. He has drug tested before and they've all come out negative. This is his first MTR. He seems to be doing very well on the deferred adjudication. He understands he's up in front of you with the full range of punishment and kind of going open to the court, but wanted to address the court and ask that if he could have a less structured modality that he could continue to work.
All right, before you address me, any objection? I haven't opened it yet, but any objection to the court reviewing the court summary? All right.
Next, or do you have a
Oh,
copy?
yes, they emailed me.
Okay.
I received it by email, but I don't open it until parties have no objection. All right, probation, what are you recommending?
Recommendation is for residential treatment at SATIF followed by aftercare and continued on the ISP case.
Is it possible to do, just do the aftercare portion, or has the time frame between being in SATA?
Well, he didn't do SATIF the first time, Judge. He did local ISF.
Ah, okay.
So as you know, local ISF is more geared to cognitive, and then the SATIF has that substance abuse. I was in the midst of looking up why he did not qualify for drug court, if you would
Yes,
like to know that.
yes. And then you want to raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
My name is Christian Grant Hogan.
All right, so it appears there's something you wanted me to
Yes.
hear. Did you want him to speak to me, counsel?
That's his intention. It's your intention to address the court, correct?
No.
Yes.
I just want to let you know, ma'am, I understand this, what they're recommending. I just feel like, and it's been fair since I've been in your courtroom, ma'am. I already completed ISF, which, yes.
So here's the thing, let's get to the crux of the problem.
Yes,
The
ma'am.
problem is You didn't report for your UAY.
One time, ma'am, I was.
No, let's not do the one time,
Well,
because
I'm
one
saying-
time is enough. Wait. We have to speak one at a time. And so let me explain something to you. So don't tell me it was only one time. And the reason why I tell you not to tell me that is because those are conditions of your probation. One time for anything is enough for you to be revoked and sent to prison. So don't say it was just one time, because that's making excuses, right? Just tell me, why didn't you report?
Well, when I first got out, ma'am, I'm gonna get to that. I was doing well. I was remodeling homes for my brother, and I was always in contact with my probation officer, and I had just lost my efficiency, ma'am, and so being in the streets, having my things stolen, lost the storage, and so and these are not excuses, ma'am, these are the truths. I had trouble with cell phone, and I always made sure I emailed when I didn't call her, and so fast forward to the motion to revoke, I had just spoke with her, I wanna say 7 days prior to the motion to revoke, because I hadn't been able to speak to her, and that's the reason why I missed it, because I'm having to deal with wanting to get shelter, and I was living in Fishing, and I went to the hotel, and it was just hard, ma'am, and that's just all I can tell you.
Here's the thing, I'm gonna give you a choice. These are your choices. There's no other choice, right? Here's your choice. I can revoke you and I will sentence you to 2 years in the prison. That's one choice. Or either your second choice, I will continue you on probation. And what I'm going to do is it's going to be an intensive supervision. And I'm going to start you off with GPS. And that will be partial GPS for employment only. Those are your two choices. There are no other choices. Do you need to discuss that with your attorney?
No, ma'am. Could you please waive the fees on the GPS?
Yes.
Yes, ma'am, I can do it, ma'am.
All right, Ms. Abrams,
Thanks.
I'm going to deny the motion. Alternate amend conditions to include partial GPS for employment only, waive fees, and intensive supervision with probation and intensive outpatient treatment with probation.
Yes, sir.
Is there anything else?
Nothing from the state, Your Honor.
Ms. Abrams, is there anything else?
No, sir.
Anything else you need from the court to be successful?
You helped me out with everything, Ms. Wood.
You're welcome. Anything else?
And I just clarified, he's on deferred adjudication, correct?
Yes.
Okay.
All right, thank you.
Judge, thank you for all your consideration.
You're welcome.
Appreciate
You're
it.
welcome.
All right, so we're going to rotate back to Judge West to finish off our day, but you can add a fourth college/university to the list, Morgan State. And Beth says potentially a fifth. So there's a thing going on today. Whether or not it's coordinated, I don't know, though I will say Towson and Morgan State are both in the Baltimore area, and both of them received their bomb threats at the exact same time, apparently. So there may be some coordinated disruption going on today. But with all that in mind, let's go back to Judge West.
They're both MTRPs, and it's just easier to find me. Good morning. Are you Lamone Yeoman Jr.?
Good enough.
And will your client waive the formal reading of the motion in each case?
He will, Your Honor.
Should have another one coming also. Okay. Mr. Yeoman, in cause number 19-32846, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 12th of 2019 for the offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct? And then in cause number 23, DCCR 1556, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 17th of 2024 for the state jail felony offense of burglary of a building. And that was a 2-year term in state jail prison that was probated for 5 years. Is that correct? Each of these cases allege that you violated your probation. Count 1 in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and specifically avoid association with any person previously convicted of a crime, or be present at a location where a criminal act is committed, in that you were supplying other residents of the Cheyenne Center with K2 synthetic marijuana. And is that true or not true?
It's true.
Okay. Count 2 in each case alleges that you failed to report to the probation office as directed April 2nd and April 3rd of 2025. And is that true or not true?
True.
Count 3 in both cases allege that you possessed a drug, K2, on or about March 30th of 2025 in violation of your order. Is that true or not true?
Not true.
Not true? Okay. Count 4 alleges that you failed to successfully complete the safety program as directed. Is that true or not true?
True.
Count 5 in each case alleges that you committed the new offense of possession of a controlled substance, penalty group 1, August 8th of 2025, and is that true or not true? Count 6 in each case alleges that you committed the offense of possession of a firearm by a felon, August 8th of 2025, and is that true or not true?
Not true.
Count 7 in each case alleges that you failed to report to the probation department April 11th, April 21st, April 30th, and May 9th, June 6th, and July 7th of 2025. And is that true or not true?
Not true.
All right. Did you enter your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of your cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand I think y'all did the paperwork backwards.
We did originally, then we corrected it. At least I thought we did.
So
There's a cap of 8 on 19-32846, and a cap of 2-year state jail on 23 DCCR 1556.
well, it's set. Hold on. Anna, can you send me back 23-1556? I just sent it.
That may be the third degree paperwork. I think he may be right.
Yeah. Okay. Yeah, I think, so 23-1556 is the burglary of a building, but y'all did TDC paperwork. And the other one, yeah. So it's got, those have to be right. So
We can read them.
I'm gonna delete both of those.
That's fine, Judge.
I'll just hold this. We'll continue the hearing. I'm not gonna go back over everything. We'll just go over the paperwork as soon as it comes through. And did y'all do it twice? You
We
said?
did, there was,
I think I got the numbers wrong. We did.
Okay,
I'll have to redo them both.
sorry.
That's my fault.
All right, I'm gonna delete both of those. All right, y'all just go have a seat in the jury box and we'll get that done.
Okay, folks, we've about reached that time to call it a day. Beth, however, has 3 more for the list, bringing up to a total of 7. Alaska Fairbanks, Alabama A&M, and Nazareth University in New York, though the last one, Nazareth, was already marked as not credible. But definitely some efforts today to disrupt our fine uni students, which is always unfortunate.
If you're going out today, be careful.
Yeah, as Beth just said, if you're going out today, maybe keep your head on a swivel just a little bit, because the world is weird. So there you go. We'll be back tonight, 8 p.m. Eastern, 5 p.m. Pacific, for Sidebar, where I believe we're going to discuss the idea of if somebody sells an illegal narcotic to somebody and that person dies from that illegal narcotic, is it murder? Is it manslaughter? Is it the fault of the person who is taking the drug and engaging in that risky activity anyways? Who's to blame and how should they be blamed? So we'll discuss that. Oh, Beth has more.
Cleveland Institute of Art evacuated after a bomb threat.
Cleveland Institute of Art is now added to the list, so that's 8 today. So a whole lot of copycatting or a coordinated effort or something going on out there today. So be aware and, be vigilant, because the world, like I said, is weird. But yeah, anyways, we'll be back tonight. We'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Half an hour early for channel members. We may expand the size of the pre-show, but not yet. Give it a couple of days while we decide what we're going to do there. But go have yourselves a safe Tuesday. Enjoy it. Be good to each other. Take care. God bless.